Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
I should have one. I haven't met him yet. That would be.
Hello. How are you doing? I didn't look at the English.
Robert Self. I do have one, Your Honor, that's on this afternoon's docket. It would be on my page 3, number 8, Randall Odom.
Is he here?
He came early, Your Honor. He said he had a doctor's appointment. You want to come up, sir?
All right.
And Your Honor, at this time, he's here for his felony plea. We're going to tender a plea of not guilty, request 15 days following pretrial motions, and request trial by jury.
All right. Not guilty. When would his court date be?
6/26.
June 26 at 1:30, okay? Mr. Odom, make sure you get with your attorney and get ready, okay?
Yes, sir.
All right, thank you.
Thank you.
Thank you, sir.
Thank you, ma'am.
Anybody else we can help?
Your Honor, I can do one other, though, but he is in custody. Okay.
How much credit does it have? So you would have to serve 2 months.
Are the private attorneys somewhere? Attorney.
Mr. Shaw and Mr. Johnson
Judge, I can call a case in just a minute.
I would object to you doing a motion. Okay.
Okay. Oh, you did. You electronically signed it. I'm looking for ones that are out, Judge. Danny Mason?
You know, court starts at 9 o'clock. I'm here, ready
Sure.
to go.
Mr.
You know,
Mason,
we
I
always
believe-
managed to start on time down at Full Walton. They had to transport the inmates all the way down to Full Walton. We always started on time. I don't know what's going on, but, you know, court starts at 9 o'clock. There's no private attorneys here. I mean, I'm a kind, sweethearted judge, but I can get my dander up, get cranky, and, you know,
Judge, I'm
y'all don't want
just
me
waiting
to,
on-
y'all don't want a kind-hearted judge to lose it and get cranky. I'm here ready to go. You know, the citizens have paid for this beautiful courtroom, and I'm sitting here and we're not using it. I want to use the courtroom.
Yes, sir.
So we'll take a 10-minute break and get some people
Judge,
up here.
I have cases I can call. I just,
All right.
a couple of them that the folks are not here.
I don't know of any judge when I was practicing law that would tolerate people just kind of, whenever we feel like getting started, we'll get started. I mean, we got people that need to get about their business, and, you know, I don't know what the holdup is, but I guess we'll have to have a big meeting where I can get on to some people to figure out why we're not starting at 9 o'clock. I think everyone knows my reputation from down Fort Walton Beach. We start right on time. I even had a flat tire the other day. I jumped out of the car in the middle of the interstate, canned it up with the fix of flat stuff, and was only like 1 minute late.
We start issuing some cases, Your Honor.
Yeah, might have to start doing that. Then attorneys can meet with their clients 24 hours in the jail, and we get here started on time. So, all right.
Crystal Hall, 20 CF 864. Judge Ms. Hall sent me an email advising that she's out sick. I've asked my legal assistant to file a waiver of her appearance this morning. If the court will allow me to appear for her, I think ultimately this is going to be a plea. I'm going to move to continue her case since she's not here, though, and is apparently ill.
Okay, did you want to go ahead and make a motion to continue it?
Yes, sir. I'll just go ahead and move to continue it.
Ms. Leon, what do you say?
We can set it for either the 25th or 30th, please.
How about the 30th?
All right, Judge.
That was Ms. Hall.
That's correct. Crystal Hall is 20 CF 864.
If y'all have a number on this paperwork, if you could tell me the number, that would really help a
Yes, sir,
lot.
Judge. I can
Okay, that's 32.
help you out with that.
Would- See, the inmates are not in any kind of alphabetical order, and I'm hunting around looking. Okay, what's the next one?
I'm sorry, that's going to be May 30th?
Yeah.
All right, Judge. Next one is Aldrion Harris. Judge, Mr. Harris doesn't answer. He is traveling in from Montgomery, however. I spoke with him a couple of days ago, and he's planning on being here. So if we can pass him
All right.
to the end. The next one is Danny Mason. He's 20 CF 733 and 22 CF 165. I called Mr. Mason's name at least twice earlier this morning. He doesn't answer. He was supposed to meet with me, and he did apparently call after hours, and my legal assistant's been unable to get back up with him.
State would ask for a capias, Your Honor.
All right, Capias.
No bond.
Yeah, no bond.
Thank you, Judge.
See, court's not like a McDonald's drive-through. You kind of show up whenever you feel like it, and I'll have a plea followed in a side order of continuance with extra dish of trial. We don't do court, we got to show up, you know. All right.
Judge, I also have Amanda Harville. Ms. Harville is incarcerated in the Santa Rosa County Jail. I provided a written plea in absentia with a fingerprint card. I'm just waiting for the state to sign it.
She pleading down to a misdemeanor.
Thank you, sir.
Thank you.
Does it require a score sheet?
Yes, sir. It is count 2 only, which is false name to a law enforcement officer.
All right, this is 22 CF 2440, State versus Amanda Leanne Harville. She's pleading down to a misdemeanor, false name to a law enforcement officer. The other, I guess, is going to be Nalprost, is that correct?
Yes,
Yes,
sir.
Your Honor.
All right, I'm sentencing her to a judge guilty, standard misdemeanor cost of prosecution, $50 PD app fee, misdemeanor PD fee, and the state to Nalprost count 1.
Correct.
Okay.
Thank you, Judge.
Judge, this is Melissa Sterner before the court on 22 CF 3157. Judge, Ms. Flowers is asking to enter a denial at this time and set this for a, it looks like there's a possible new law case that is the basis for the violation. Is there any way we can get those to travel together?
So currently, 23 CF 795 is set for today for arraignment. That is the new law violation to 22 CF 3157.
Your Honor, if we can enter a denial as to the VOP and enter a plea of not guilty as to the new law
All right.
violation.
Maybe we can take care of everything at once. What date, what court date do you want?
All conference, Judge.
June 26th.
And that'll be on both cases, right, Judge?
Yeah, we'll do them together.
Okay, thank you, Judge.
All right, is this Chase Stewart? Thank you.
Judge, this is Chase Stewart before the court on 22 CF 1397. Ms. Flowers is asking to enter a denial at this time and set this for the next miscellaneous dates. If we can do this for 5:30 if possible?
All right, May 30th.
And that was for 23 CF 754. He was set for arraignment. That was the new law case.
He's got a new law as well.
Yes, that was set for arraignment today. It's 23 CF 754. He's been charged by information with 1 count of controlled substance and 1 count of paraphernalia.
Your Honor, in light of that, if we can enter not guilty as to that case as well and
Okay.
set both of them for the new law, for the next pretrial.
All right, thank you.
626 for both cases.
Yes.
Yes, sir.
Mr. Harper, any others?
Yes, I believe they're bringing in an inmate with, yes.
Walker?
This is Lisa Walker. Judge, she might be on the afternoon docket. She was transported this morning, though.
Okay.
She is here before the court on 23 CF 925 and 23 CF 924. Judge, it looks like Ms. Rivers just withdrew off of this case.
That's correct, Your Honor.
In light of her medical issues, if we can set her for the next available court date so Ms. Flowers can meet with her and possibly inquire about setting it for a bond hearing as soon as possible.
What is, she charged with?
I think they're trafficking
It's
counts.
three cases of trafficking in fentanyl and methamphetamines, Your Honor. Currently was set for a bond hearing today, but Ms. Flowers, being sick, she asked to just set it for the next miscellaneous date, which I believe is going to be the availability on May 25th or May 30th.
Well, I mean, what's her current bond?
Well, I think our bonds were revoked on our first trafficking case. I don't have, the other two files are
She's
on for
what?
the afternoon.
She just stated that she's in hospice.
On hospice? She's in a wheelchair. Is she on hospice? I mean, you have family here? Is he here in the courtroom?
No, sir, he's been here this morning.
Your Honor, may we approach?
Yes, this just pertains to 23 CF 179.
All right, so he still has another case pending?
He does.
Okay.
Thank you, Your Honor.
Thank you.
That's all I have this morning.
Thank you. All right, Mr. Powell. Mr. Powell, come on up.
Good morning, Your Honor. Welcome.
Good morning, thank you.
Glad you're here. Have Mr. Miles, Your Honor,
Okay,
Jason Miles. This is a VOP and got a suspended sentence, so I'd asked to, we're trying to work it out so we could pace it again. He's not going anywhere. He said,
okay.
but if we could pass it to the next VOP docket or miscellaneous docket, if that's okay.
No objection.
How about May 30th?
No objection.
May 30th is perfect.
Is that okay?
Yes, sir.
Okay, good, thank you.
I'll be around to see you. Next case I have, Your Honor, is Christopher Kearns,
Okay,
and that's a PTI referral. I've already talked to probation. Mr. Kearns works out of town on rebuilding turbines and stuff, so he's got a real good job. He was supposed to be here today because we put it off, but he called and asked if he could come next week, that he needed to stay and finish the job he was on because it was making good money for that. But it's all agreed to. If we could just set that on another date, I don't think the state has a problem with it.
No, Your Honor.
you mean to enter some type of PTI or whatever?
Yes, sir. We're going to enter a plea and then refer to PTI.
Well, we'll just put him on May 30th, how about that?
May
Would
30th?
that be okay?
Yes, sir, that's great.
Okay,
And
Yes,
Judge,
Your
Bo had covered for me on the last couple of matters I was in trial
okay,
back to back, so I appreciate allowing him to do that. But we
Yeah.
got that case reset, and we'll resolve it at that time.
okay,
Okay.
good, thank you.
Thank you all.
Mr. Patel, you ready? What you got? An inmate?
It's Mr. Hartzog.
All right. What we want to do with his,
Your Honor?
I've got Tim Shaw as the attorney. Okay, I got you.
Your Honor, this is my case.
All right,
And Your Honor, the court has has signed an order transferring this case to Judge Ketchell's division. This case was originally before Judge Polson in Division 1. It was transferred up to Judge Ketchell's division, Division 6, when Judge Polson recused herself. The state filed a motion to return this case back to Division 1, and which would place it back before Judge Ketchell, where it originally came from. It's customary, of course, to try the cases where the crime occurred and where the witnesses are, and the court has, in the meantime, signed this state's motion to transfer it back. So we believe any further hearings should be held in front of Judge Ketchell.
so did I sign an order?
Yes, Your
I
Honor, the court did. We let the court know that it wasn't opposed, but it was signed. We don't believe there's any legal basis to oppose the transfer back to where it came from. There is no conflict with Judge Ketchell, and that's where it most properly should be tried. So we believe the court signed that properly.
Judge, if I may respond.
Okay,
Jay Patel and Tim Shaw on behalf of Jesse Hartzog, 20 CF 2976. Judge, Mr. Shaw and Mr. Flowers, covering for Mr. Shaw, were before this court, albeit Judge Oberleisen on the last pretrial date. The state filed a motion to transfer divisions. Judge Oberleisen asked whether it was opposed. We stated on the record it was opposed, and we object. The state that afternoon filed a notice of hearing because it was set for today at 9 a.m. That afternoon, inexplicably, the court signed that motion transferring the division without our client having the opportunity to be heard, for him having notice and being present, and us having an opportunity to be heard after our objection. We filed a motion for rehearing or reconsideration on the matter and noticed it for this morning. I do have an objection.
so so the record's clear, I mean, this is like my first week up here. And we had a whole bunch of different judges signing stuff and having different hearings, making different rulings. And so apparently it was, Mr. Hartzog was in front of Judge Polson. She retired, and then it went to Judge Ketchel up here. Is that right?
No,
Your Honor,
Judge.
she recused
Oh,
herself, and then it came to Judge Ketchel up here because there was no conflict.
Yeah.
So when Judge Ketchel moved down into Division 1, where this case originally came from, the state filed a motion to return it to Division 1 because we don't believe there's any conflict, and we believe that's where it's appropriately heard. So that's our position.
What? I mean, I don't mind trying the case. I
But,
mean,
Your Honor, we believe it belongs appropriately in Division 1 where it came from. And so we're just asking that it be returned to where it originally came from. That's where the witnesses are, that's where the crimes occurred. That is how we do it, that the cases are tried where they occurred. There's no reason for it to remain up here.
There is.
all right.
What would that be, Mr. Patel, please?
So we got a hearing scheduled today as to why it should stay up here.
We're not aware of any legal basis, Your Honor.
What?
Are we having the hearing?
I mean, is it set for a hearing today?
We noticed our motion for rehearing on on the order transferring the division without us having a hearing.
When did, I sign the order transferring division?
Yes,
To me,
just
that's just a
couple days
You
ago.
probably come through with a ton of other routine orders like granting continuances or deny, So I didn't know this was, there was an objection to it. Is this hearing going to take a long time?
I don't think so.
Okay, why do you think it should stay up here?
Okay.
Or with me?
There's a couple reasons, Judge. One, it was the state's motion to transfer division doesn't state any rule. When Judge Polson recused, it was moved up to this division. It just so happens that Judge Ketchel was in this division. When I read this motion to transfer division, what I'm seeing is really a motion to disqualify you without any facts. It should be, again.
Motion to disqualify me?
That's there is no rule transferring divisions.
I haven't been disqualified yet that I know of. I mean.
And I'm talking about the
Hardly
rule.
ever happens, but.
And I'm talking about rule, if they feel prejudice, then they can file a motion to disqualify under Rule Judicial Administration 2.330. They filed a motion to transfer division, which seems to be guised in that. I don't see a rule saying that just because the state says that's the way we do it, and that's what we think is appropriate, isn't right. Their witnesses are Okaloosa County Sheriff's deputies. They're in Okaloosa County. It seems that it's just forum shopping to me to get Judge Ketchel as opposed to you. Now, the most important reason why it should stay in front of you is because why did Judge Polson recuse? The reason why is because my client's mother, Andrea Hartzog, that's present here, was a supervisor for the guardian ad litem. She worked hand in hand with Judge Polson, just like she's worked hand in hand with Judge Ketchel. I found this out about her relationship with Judge Ketchel about 10 days ago.
She's worked with me, haven't you, in dependency court?
And I don't know the nature of y'all's relationship, but then it would seem to me that both Judge Ketchel and yourself need to have to make that consideration. But I think for the purposes of now, Ms. Hartzog has told me that she's worked hand in hand with Judge Ketchel. Finally, another reason why it should stay in front of you is because you did the sentencing for the defendant, Yanni Giannos. I think that if the state is concerned about judicial efficiency and economy, then it would make sense to have a judge that had already sentenced a co-defendant to handle this case.
When did I do that sentencing?
Yes, Your Honor, the court did that sentencing. May I be heard, or?
Yeah.
Okay. I want to be clear, Your Honor, on behalf of the state, we are not in any way implying that the court should recuse itself or that we object to Your Honor hearing the case. That's not the case. As far as the argument of Judge Ketchel possibly having a conflict. This case was placed before Judge Ketchel here in Division 6. He never indicated there was any reason that he was concerned that he might need to recuse himself. We frankly were never told the reason why Judge Polson recused herself. She just signed the order recusing herself. But Judge Ketchel never had any concern. So as far as him being able to go forward on this case, the state has no concerns on that. The court did not have any concerns. We do maintain that it is appropriate to return it to Division 1 because that is where it was originally heard. As far as this case, as far as this court hearing it because you already heard co-defendant, as this court is well aware, each case stands on its own. They're separate and distinct. Mr. Hartzog's facts and circumstances, frankly, are totally, they go beyond what the other client did, what the other defendant did. So we wouldn't be relying on any of that. We rely on Mr. Hartzog and what he is alleged to have done. And if he is in fact convicted or pleas, then the court would of course hear those facts and circumstances and treat him as an individual in accordance with the law. So that argument we believe the court needs to set aside as far as that you've already heard the co-defendant. But
I don't remember anything. I don't remember the co-defendant. I mean, did I do it the other day?
it was one of the last ones you did, Your Honor, before you
Did I
left the
do it
criminal bench.
a couple years ago? or
Yes, sir.
something?
That was
So I
also
don't-
with me.
I don't remember anything about it.
Right.
You know.
So that, we believe that's really not even valid here. But we are merely seeking to return the case to where it should have been to begin with, which was Division 1. That's where the clerk assigned it. It only left Division 1 because Judge Polson could not hear it. Judge Ketchel is now sitting on the bench in Division 1, so it's appropriately back in Division 1 with Judge Ketchel. And that's all we're asking the court to do.
Judge,
We don't move cases around just because the defense wants them somewhere different. We believe it belongs back to where it started because there's no reason for it not to be there.
Actually, I think we're here because the state wants to move it around because the state wants to do that. I'm just asking for a rule because there is no rule in here. State's argument is, well, that's just the way we do it.
Well, I don't mind hearing the cases, trying the cases, but I don't want to violate some administrative rule that we have that Judge Stone or some other Judge Flower, whoever was administrative judge may have entered some rule. Does anyone know of it? I mean, it was a
Your Honor, the case occurred at the south end, the arrest was made in the south end, and it's placed before a court in the south end.
Judge, how I understand it is when a judge recuses, the administrative order is that the chief judge in the county then reassigns it to another division. That's what's happened here. So I would love for the state to give us one rule that says why it should just automatically go back.
When is this set for trial?
Your Honor, we've been trying to bring this to trial for several years now. I don't know that
He's
it's...
been in jail for years?
No, Your Honor, he is back in jail because the state filed a motion for, or pretrial services filed a motion for bond revocation based on recent actions.
Judge, we're getting pretty close to trial. We got to file a motion to suppress. I think we have a meeting at the sheriff's office. We got to file a motion to suppress, and then we're going to be ready for trial.
Well, if you're not ready for trial right away, what I suggest is we continue this, and then I can check with the administrative judge about, I mean, I don't mind trying the case. I mean, and I don't want to violate whatever administrative rule we may have.
Does the court wish to reset this then, or?
I'm sure Judge Ketchel, he don't care to try the case. I mean, that's what we like to do. I mean, I don't know.
He was ready to, Your Honor, so.
And again,
But right now, it's in front of Judge Ketchel.
As of,
It was in front of Judge Ketchel.
yes, sir.
I've signed an order saying it goes in front of Judge Ketchel. Why don't y'all argue this in front of Judge Ketchel?
no, Judge.
That's what the state believes should be done, Your Honor.
No, the case was moved to this division. Now that Judge Ketchel happened to sit in that seat, And now that Judge Ketchel has moved to another division, they want to move it in front of him. It doesn't make any sense to me. So all I'm asking for is a rule. It doesn't seem like we can get one.
Well,
And then the concern that we have
I don't
based,
think there's any criminal rule or anything like that. It's just an administrative type situation.
I looked all last night. Couldn't find anything.
I don't mind keeping the case, but if I've already transferred it, I don't think I can do anything without talking to Judge Ketchel. We get these routine orders all the time, and, you know, that I think they're stipulated to get in front of me as an order, but
Your Honor, if I may suggest, Judge Ketchel does have a miscellaneous date on the 9th next week. If we could just set it for the 9th, and then we can address it at that point, since that's where it is right now.
yeah, get it in front of Judge Ketchel on the record and see what he says.
All right, can we
Judge,
do that the 9th?
Well, hang on. So, and just so I understand and the record's clear, I asked the court for a motion for rehearing because my client was prejudiced by not having an opportunity to be heard when we objected to the state's motion.
I know, and now I've ruled, you had your hearing, I've ruled that the proper
We-
thing to do is to stay this until it gets in front of Judge
So-
Ketchel, and see what he says.
Well, so then my understanding would be that if you're staying it, then, well, you tell me, sir,
I'm not going, what my order is that now it's technically in front of Judge Ketchel. Didn't I sign an order?
Yes, Your Honor, the
It's in
court
front of
did.
Judge Ketchel. So now I'm making a ruling that may be different than what Judge Ketchel says. Actually, it's in front of Judge Ketchel. So see what he says. I don't mind trying the case. We got a great courtroom. I love trying cases, tried about 20 first-degree murder cases as a defense attorney and prosecutor and everything. I mean, I love trying cases, and this would be probably a pretty interesting trial, I guess. I don't know the facts about it. You know, and I'd like to try some cases.
and Judge,
Give me
We'll
10 or
have plenty,
15
Judge.
case tries a month. I
Judge,
mean, that's
just-
fine with me.
just so
You know,
just so
I'm
I
trying to
understand.
beg people to go to trial. Everybody want to chicken out and plead, you know, but
Judge, just so I understand, we filed the motion for rehearing timely. If you've accepted that, then essentially that previous order can go away.
I'm just letting Judge, it's actually in front of Judge Ketchel. I'll let him make the decision. Talk to him about it on the record, like you're doing here. And if he wants to talk to me and our administrative judge about it, I mean, I don't mind trying the case, but I don't want to violate some administrative rule.
Your Honor, does the court then wish it to be set for Judge Ketchel's next available date, which we believe is the
If it's in
9th?
front of him, because I've signed an order, you see, I get these orders that are rather routine, like a continuance, and it's supposed to be stipulated to by Mr. Patel's got an argument there that apparently they
We-
filed some, which I didn't know. Sometimes the clerk, they're so overwhelmed, they don't get things on the docket. I mean, they file a motion. I got court the next day. I don't see it because it's not on the record yet, you know. But, you know, like I said repeatedly, I don't mind trying the case. I want to try some cases. I want, you know, that's what I did in Fort Walton. I want to do it here, but I don't want to upset our judicial administrative rules. And, you know, we had Judge Polson, I guess, on this case. We had Judge Ketchel on this case. I think, do we have Judge Oberleisen on the case?
No, sir, he was just the senior judge that day. That's when we were doing the visiting judges.
But there was something that happened in front of him. And now you got me.
Because it was in the right division, that's why Judge Oberleisen heard it.
I bet you Judge Ketchel says, I don't care, I'll hear it, I'll try it. I mean, you know, I don't, so.
And Judge, the concern now is based upon what I've learned is we're going to file a motion to disqualify Judge Ketchel based upon the
I don't know what you're
relationship.
going to do or not do, but I need to get it in front of, y'all need to get it in front of Judge Ketchel, because technically it's in front of him now, and I really shouldn't be making any kind of ruling, so I'm going to just continue this and see what he does.
Judge,
Thank you, Your Honor.
that's what I don't understand. I feel.
Mr. Patel, how many times do I have to tell you?
I understand, Judge.
I'm a kind, soft-hearted judge. Everyone knows that. I'm so soft-hearted that the state can't stand me to have cases sometimes. Ms. Leone always talks about I'm too flexible, I'm too easygoing, and, and I am, but when I make a ruling about 4, 5, 6 times, I mean, I don't need any more rulings on. I'm trying to be considerate to you, but the thing to do is, it's in front of Judge Ketchel right now, whether it's by a mistake or something, you need to point out the mistake to him. I mean, like I said, I'd like to try the case, any number of cases. I don't care, I'll try cases, but if it's really in front of Judge Ketchel now, because I signed some order which I thought was stipulated to, bring that up to Judge Ketchel. I mean, we're not going to trial next Monday. I mean, it's not like it's trial Monday. We can get this worked out. But
Judge, I just want to check with Madam Clerk that based on today's minutes, will that then appear on Judge Ketchel's docket?
Judge, and if I may, Tim Shaw for Jesse Hartzog as well. I think one of the other problems that we've got is, and I think the court touched on it, of course, was that, as the court mentioned, you didn't know, I guess, when you signed the order that it was objected to. So
when I get those routine orders, they're all supposed to be stipulated to.
yeah, it was not stipulated to, and in fact, the state that day, knowing that we objected to it, filed a notice of hearing for today on their motion to transfer. So it should have never been entered, and we timely filed the motion for reconsideration. I understand the court's ruling. The problem I've got, though, is that the same day that all that was happening, pretrial services files an affidavit alleging that Mr. Hartzog had violated his pretrial release conditions by being on the internet. The affidavit, the purported affidavit, which has him in jail, he's been in jail for 10 days on a violation of pretrial release. The affidavit isn't even really an affidavit. It says somebody else told me that this is what happened. So there's no firsthand knowledge. There's no knowledge. The allegations that he's on the internet are so weak.
Well,
I can't believe.
This sounds like some kind of bond hearing.
Well, 'cause we had both set for today. We had the motion that Mr. Patel was arguing to keep the case here on the motion for rehearing or reconsideration, it should be, because we never had a hearing, on the transfer. So that's why it was set for that, and we noticed it for the bond to reinstate the bond. So if the court doesn't keep the case here and sends it down to Judge Ketchel, this gentleman has to stay in jail, and our belief, wrongfully, because there's nothing in that affidavit of personal knowledge of any violation. And so he should be out of jail. So we're going to keep him in jail to go see Judge Ketchel because of this snafu. And when I say snafu, that an order was entered without knowledge that we objected. So that's the problem.
Okay.
And Judge, I can tell you this, I personally got online on the First Judicial Circuit website, looked at all Okaloosa County orders going back for administrative orders for years, and I don't see any procedure, and I could have missed it. I'm not the greatest computer researcher in the world. I could have missed it, but I don't see any basis for what Ms. Basso's motion sought to transfer it back to a division that's been properly transferred out of.
The transfer of divisions is because, I don't know of an order, but usually transfer of division is some judge is recused for some reason. I don't know why they recused. They don't know why I recuse if I have to but they've recused. It goes to the clerk, I think, and then the administrative judge signs it just to another judge that's in the same kind of criminal division or whatever it is. I just thought someone recused, and for some reason, some senior it was supposed to go to, it was a mistake. It was supposed to go to Division I instead of here, because we've had so many different judges and.
And I think you're right.
Isn't this my first week?
You're accurate, Judge, and I think you're accurate.
This is my third day in court, and I'm trying to,
I think you're accurate that when there is a recusal, like we had in this case from Division I to Division VI, that it did follow an administrative rule, an administrative order that got it to Division VI. I don't see, and again, like I said, if I'm wrong, I'm wrong. Somebody show me the administrative order where, because later there's a change in judicial assignments that you then can just transfer the case back to the division that it came from. I mean, that makes no sense. There's not a rule, there's not any authority for it. But that's what Ms. Basso wanted to do.
Well, you want it heard in front of Judge Ketchel, I guess, and you want it heard in front of me, is that right?
We want to leave it in the division that it's properly assigned to at present. There's no authority to transfer it to a different division, none. And I know Mr. Patel asked Ms. Basso several times, show us a rule, show us an order, show us something where we're wrong. And if we're wrong, we'll say, yeah, Judge, we're wrong. But there's no basis for what she requested. There's no legal basis for what she requested that I've been able to see. And so, and the problem is, we got a gentleman sitting in jail that, in our estimation, shouldn't be in jail because of an alleged pretrial release violation.
All right, well, I understand, but see what Judge Ketchel says. Thank you. Is that just a routine docket for him? Yeah.
Do we know the date? May 9th? Thank you. Thank you, Judge. May I be excused? Morning, Your Honor.
Morning.
Okay. They got somebody to get pulled.
Who else we got?
Mr. Gibbs has got some.
If they're already there, we can do that.
Sure.
That works.
Your Honor, we do have one gentleman that's unrepresented as well, whenever the court wishes.
Remind me, we'll do it after Mr. Okay, what you got?
Your Honor, this is Ms. Jennifer Albro, 21 CF 2514. Tim Gibbs on behalf of Ms. Albro. Judge, she's set for a VOP arraignment this morning. We'd like to enter denial and leave this set for May 25th without subpoenas. We'll be looking into referrals for inpatient treatment.
Any objection on that?
No, Your Honor.
All right. May 25th, thank you. Do we have some person here that has business but doesn't have an attorney?
Your Honor, it's Mr. Brian Williams.
Where is he?
Your Honor, Mr. Williams was previously represented by Mr. Moore, and he's currently on probation. Let me grab his file. Up there. Your Honor, Mr. Williams is currently on probation. He was placed on probation for about a year. One of his conditions was no contact with the co-defendant, and he has asked for a modification of those conditions. And even though he's unrepresented, Mr. Morris is not available, as the court is aware. The state has no objection to that particular request. It was e-filed on 12/22/22 by Mr. Moore on Mr. Williams's behalf. I have a copy if the court needs it. But he does make a second request in that modification request, and the state is objecting to that. That is to be able to report by electronic means or by telephone only.
I was asking for the telephone. Is this working?
Pull it down there for you.
I was asking for the telephone report. I was on telephone reporting. Didn't have a problem. Don't see any reason why I shouldn't go back to that.
So he is wanting to have contact with somebody, which the state does not object to, correct?
Yes, Your Honor. Just for the record, was his co-defendant, Ms. Hatis
Okay, so you have no objection to that.
That's correct, Your Honor.
And then he wants to report to probation by telephone? Is that what you're asking?
Yes, sir.
Is probation, did he used to do that?
Yes.
Mr. Berry?
Your Honor, I don't have that information. If you can give me a minute, I can find out if
Okay.
he was on telephone reporting and then was taken off.
Why do you not want him to report by phone?
Here's the
Do you mind if I?
paper they
Yeah.
gave me to
got
set it up.
He's got something right there for
Do you
you.
mind if I look at that?
Sure.
Go ahead, that's what they gave me to set it up.
That would be what we gave him to set up his report by phone. That is absolutely correct.
Well, if the probation has no objection, then we'll leave it at
Okay,
the
all
board's
that's
discretion.
granted then, okay? How about an order? It's granted. Okay?
Okay, thank you.
Figured we
See,
could
you
take
won
care
your
of it.
first, you won your first case representing yourself. Very good.
Thank you, sir.
All right.
Thank you, Your Honor.
Mr. Williams.
All right. All right, this is Alex Tristan Coffin.
Yes, Your Honor.
Okay.
Case number 2021 CF 1226. Mr. Coffin, we had set it for today without subpoenas because we anticipated there's a plea offer. I've talked to the state. Mr. Coffin has had some confusion. He and I are going to have, between Monday and today, we were not able I was not able to get back over here to the jail due to my schedule. And so the state has agreed to
May 25th?
May 25th, extend the offer. It will be revoked after that date. So
Okay. Is that right, Ms. Brinkman?
Yes, that's correct.
Okay. Thank you. I'll see if you can work it out.
I will. Yes, sir. Thank you, Your Honor. That concludes my business with the court. May I be excused?
Yes, thank you.
Your Honor, I don't have anything further if I could excuse as well.
Very good, thank you.
Thank you.
Good morning, Your Honor. Tim Gibbons on behalf of Wendy Boardman, 22 CF 1407. Judge, we're requesting a continuance to May 25th. We are awaiting evaluation report from Dr. Zeman regarding Ms. Boardman's competency.
No objection.
What was her name?
Boardman, Judge, she is number... Correct. Or 15 on my docket, but 7... It changes, it's not final until it gets printed this morning.
All
And even
right,
then-
you want to, is that a continuance till May 25th? Is that what you said?
Yes, Your Honor, in the morning without subpoenas.
All right.
No.
Okay, granted.
I missed the date. I'm sorry, Mr. Gibbs. 25th.
Your Honor, Tim Gibbs on behalf of Alexis Doherty. This is 21 CF 2080. If I may have just a moment with Ms. Doherty. And today's date, please. Today is May 4th. Yes, ma'am.
Ms. Daughtry, would you please raise, Ms. Daughtry? Ms. Daughtry, is that right? Daughtry?
Doherty, yes.
Daughtry? Okay, yeah, I see. Would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes.
Thank you. All right, you want to enter an admission to a violation of probation, is that correct? Did you read and sign this plea and sentencing form agreement?
Did you read and sign the agreement?
Did you? You think so?
If you want to reread it, we can.
This waives your rights to,
Yes, I signed it.
it waives your right to a hearing in front of me and making the state prove its case against you. You understand that that's what this is saying, your right to remain silent, various other rights. You read and signed this, is that correct?
Yeah, he's holding up the form that we just signed. He
Okay,
wants to make sure
yes.
that you sign that and that if this is what you want to do.
Yes.
Are you under any drugs or medication that prevents you from knowing what you're doing here today? No? Anyone force you or threaten you to enter this admission? Are you happy with the work Mr. Gibbs has done on your case for you? Court finds the admission freely and voluntarily entered. Court accepts it. Court revokes and terminates probations, enters a new term of 11 months, 29 days probation, waiving cost of supervision, allowing mail-in probation while living with her father in Knoxville, Tennessee, allowing her to travel to Tennessee, $100 cost of prosecution, $150 PD fee, complete the original requirements, including a substance abuse evaluation, and any recommended treatment and adjudication is withheld, correct? Thank you.
Thank you.
Your Honor,
Yes.
I'm sorry to muddy the waters, but I just received a text on the gentleman that was just in here,
Yeah,
and his offenses are sex offenses. And our office mistakenly, at how he was classified in our office at the time, before they just saw all this going on, is they were going to, he was eligible to report by mail. However, since they went and looked at this when this hearing started, he is not eligible to report by mail. And I will get him back up here in just a second if that's okay by the court.
yeah. Okay,
Okay, I
Yeah.
apologize for that, but they just saw that on the
I
video
understand. I
and
mean-
they said,
but you were so enthusiastically supporting of him doing it.
I was.
Well, there's
He
no
had the paperwork
problem.
to prove it.
I asked Mr. Berry, he ran up here and said, yep, that's what we did, yep, that's fine, yeah. So he only won half his case, I presume, so the other hadn't been ruled on yet. Okay,
He's on his way back up here.
all right. You were very enthusiastic to support his position, so it kind of,
Your Honor, Tim
Okay.
Gibbs on behalf of Ms. Amber Barrow. This is 22 CF 2602. Judge, Ms. Barrow was previously released on this violation of probation with a stipulation from the state that her bond be modified to a signature bond. That order was signed, I believe, by Your Honor, or at least by this court, on April 20th. The conditions of that bond were that she report to pretrial services within 24 hours, as well as to Terry Henderson within 1 week of her release. My understanding is she has reported. Pretrial services had filed an affidavit of violation that she had not reported to pretrial services within 24 hours. That was honestly my mistake, Judge. I had put pretrial services on there when it should have been probation, because this is a violation of probation, Judge, 22 CF 2602. And not a new law violation, so that was my mistake. Pretrial, again, did file an affidavit. I would like to make an oral motion to simply reinstate her bond. She had contacted Terry Henderson. However, my understanding from talking with the state, drug court may no longer be an option. We'll otherwise be looking at inpatient options or other treatment options for her in trying to resolve this case. But again, that was my mistake in putting pretrial. It should have been probation and standard conditions. I believe she would have had to report to probation, but she wasn't necessarily instructed by the court to do so.
okay.
State objection, Your Honor. There is no notice for this bond motion. And I discussed this previously with counsel. I said that I would need a written motion for bond. I worked on the order for bond to let her out after she was arrested, and Mr. Gibbs, the defense, knows about it. She violated those conditions. The offer that was in place is revoked right now.
Well, she went to the wrong place that Mr. Gibbs told her to go report.
The orders, I had, honestly, Judge, I had drafted that order, and it did say to go to pretrial services. That was my mistake, and that's what I had in my head. I should have put in that she was supposed to report to probation since she's on probation. So pretrial, having a copy of the order, noting that she had not reported to pretrial services within 24 hours of her release, of course, filed their affidavit. That's the basis for why her bond is currently revoked. It was in the order. It was signed by the court, and I imagine Ms. Barrow was indeed aware of that requirement. However, that's why I simply did an ora tennis motion. She had just been arrested yesterday. She's actually, I believe, just had her first appearance on the issue this morning, or she's waiting to do that. She had her first appearance this morning on that. That's why I'm simply asking the bond to be reinstated to what it was from the order that the court signed on April 20th.
Your Honor, the state is going to ask to continue this hearing to the 25th, where I have a chance to bring here pretrial services and evidence as to what she was advised to when released from jail. Without that information, I cannot go forward on a hearing.
Well, I'll continue it to the 25th. If y'all can talk about it and get
Thank
it
you.
resolved,
Very well.
and send me an order.
Thank you, Judge. Otherwise, Judge, this is her arraignment on this VOP. We'd otherwise enter a denial.
Okay. If y'all can figure out something, send me a
We
stipulated
can come up
order.
with something, Judge. Okay.
Mr. Williams, come on back up.
Wrong one. Here.
Apparently, the probation had thought that you were allowed to appear by phone, but because of the charge you had, apparently you're not, is what Mr. Berry's informed the court because of this, not that they've have any objection, I guess, but because of the statutory requirement. Is that right, Mr. Berry? You've got to appear, you cannot appear by phone,
Right.
I believe.
He was mistakenly entered into our system as not a sex offender. However, we have determined that he is, and he must report in person. What triggered this letter that he showed me was when he was in a different classification within our system, he would have been eligible to report by phone. However, when we re-looked at it, we had him classified incorrectly. Now we classified him correctly today, just now. And that letter he's got is no good anymore that allows him to report by phone.
Yeah, well, the law is the law. I'm going to let you have contact with that person, but then you're going to have to report in person, okay? Thank you.
That's correct, Your Honor.
Thank you. Yes.
Haley Stofflet, Stolflet, 20 CF 453. Judge, it had been Mrs. Flowers' intention to continue this, but I've called for Ms. Stofflet a couple times this morning and approached everyone in the courtroom, and it's my understanding she's not present.
State would ask for a KPS with no bond.
Okay, granted.
Thank you, Judge. That's all I have this morning.
Thank you.
Mr. Batson.
Your Honor, Tim Gibbs on behalf of Edgar Allen Batson. This is 21 CF 733. Judge, he also has a new law that I believe is on this afternoon, 23 CF 801, but we are prepared to resolve both of these with a plea this morning.
Thank you.
Sign right there for me, please.
Yes, I'm trying to find something. I do have it. Is the primary offense date that I'm looking for, because that's what I want. Okay, I got it. 322.
If I may approach, Your Honor.
I
Apologize in advance for the
Mr. Batson, would you please raise your right hand to be sworn? You swear the testimony you give forth is the course of truth, so help you God?
Yes, sir.
Thank you. All right, you want to enter a admission to violation of probation in 21 CF 733 and enter a no contest plea in 23 CF 801 to driving with no valid driver's license, a lesser offense, a misdemeanor, correct?
Yes, sir.
Is that right?
That's correct, Judge.
Okay. So down from a felony to a misdemeanor. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this admission and plea?
Yes, sir.
Anyone force you or threaten you to enter this admission and plea? Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done on your case for you?
I couldn't understand you, sir.
Are you happy with your lawyer's work for you?
Yes, sir.
Court finds the admission and plea is freely and voluntarily entered. Court accepts it. In 21 CF 733, the court's going to reinstate, modify remainder of probation and community control, $100 cost of prosecution, $150 PD fee, complete original requirements of probation, money to collections if not paid by termination. In 23 CF 801, you are sentenced to time served in the county jail, $300 court costs, including $50 cost of prosecution payable in 21 CF 733, and you are adjudicated on both cases.
Thank you, Judge.
I guess you're getting out of jail today.
That's the plan, Judge.
Okay, thank you.
And Your Honor, the same blurb would apply to those court costs also, if not paid within termination, they would go
Yes.
to collections?
Yes.
Thank you, Your Honor. And of course, we request to continue waiving costs of supervision, Judge.
Oh, okay.
Thank you, Your Honor.
All right.
Your Honor, Tim Gibbs on behalf of John Boujno. This is 22 CF 590, 22 CF 1406. Judge, we're working on getting him approved for the Keaton program. We'd like to continue this case so we can get that approval and try to get him sentenced to that.
No objection.
All right. May 25th. Thank you.
Your Honor, Tim Gibbs on behalf of Michael Coughlin. This is 22 CF 873 violation of probation. If I can have just one moment with Mr. Coughlin.
All right.
Days of credit. And today's date, please. May 4th.
Mr. Gibbs?
4th. Tomorrow's my mom's birthday. 23, right? Yeah.
Yes, sir.
It's right in the back.
Your Honor, if I may approach.
Yes.
Court sheet included, no objection.
Mr. Coughlin, is it McHale or?
McHale.
McHale, would you raise your right hand to be sworn? You swear the testimony you give forth is the course of truth, so help you God?
Yes, I do.
You want to enter in 22 CF 873, you want to enter an admission to violating probation?
Yes, sir.
You can put your hand down. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
Sir?
Were you forced
No,
or
sir.
threatened to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing today?
Sir.
You happy with the work your attorney, Mr. Gibbs, has done on your case for you?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court revoke and terminate. Sentenced to 90 days, Okaloosa County Jail, credit for time served, $100 cost of prosecution, $150 PD fee, money due in 180 days or to judgment, and you're adjudicated.
Sir.
Thank you, Judge.
Thank you.
You have a good day.
Thank you.
Within the case you need to be free. Yeah, good luck.
Yes, sir.
He's also on the plea.
Yes. Your Honor, Tim Gibbs on behalf of Justin English. This is 22 CF 3185, 21 CF 2151. Judge, he's also on this afternoon's docket on 23 CF 739 for arraignment. Judge, in Mr. English's cases, we're working on resolving those. I had noticed some score sheet issues that I brought to Ms. Leon's attention. I think she still needs some time to review those. I'd like to set him for May 25th to continue his arraignment as well as his VOP arraignment, so perhaps we can get the cases resolved by then.
No objection.
Okay, so arraignment and VOP on May 25th?
Yes, Judge, if we can do it in the morning.
I mean, the arraignment, do you want it to arraign him now?
We can waive arraignment and.
That's what I'm
I
saying.
believe you filed an information, if I'm not mistaken.
I did.
We can enter denials and not guilty and just set it for
Okay,
status
well,
then.
Yes.
he denies and not guilty at this time. Okay, all right,
And then leave it for status on the 25th, Judge.
all right, May 25th.
Thank you.
Thank you, sir.
Get it taken care of. I think that concludes my business this morning.
Got Mr. O'Quinn.
All right.
Good morning, Your Honor. This is Tyler O'Quinn. He is before the court on two cases, 21 CF 1972 and 22 CF 523. We filed a motion for rehearing. The state filed a motion to strike. And we're ready to proceed if the court is so inclined. I do disagree with the state.
Is this going to take a while?
Your Honor, the state's position is it shouldn't take any time because this court has previously ruled, meaning Judge Rasmussen, on the same matters.
Oh, okay, here we go again.
Sorry.
All right. So what was your motion? Apparently it was all this was in front of Judge Rasmussen. He entered some type of decision?
Yes, Your Honor. We did file a motion to dismiss 4 of the 5 counts as double jeopardy. And I did have an opportunity to argue the case law that I had presented to the court. Ms. Basso presented some case law. She got to argue. The judge then quizzed me. I didn't really have the opportunity to review and respond to the case law that Ms. Basso presented, and I would like that opportunity.
Well, what do you say, Ms. Basso?
Your Honor, we believe that Judge Rasmussen had argument from both counsel. He had the case law itself in front of him, so he certainly could read it and make his own determination, and we believe that he had the appropriate information to make an educated, learned ruling in accordance with the law. We see no reason to overturn that.
Ms. Rivers, did you make your argument in front of Judge Rasmussen? I mean,
Yes, Your Honor, I did make my argument citing the Supreme Court cases. Yes, Your Honor, I did.
all right, well,
But I didn't really have the opportunity to respond to the cases that Ms. Basso presented.
I'm denying it. Judge Rasmussen heard it. He made a decision, and if the appellate court reverses it, I'll be happy to follow whatever the appellate court tells me to do. Thank you.
When we come back.
Not this Monday, but the following Monday.
All right, Ladarius Purdue.
Your Honor, I believe he was set for a status. He was previously found to be incompetent due to intellectual disabilities. He is currently receiving training at the jail. I did receive an email from Mr. Sanchez this morning indicating he had to be in 2 other counties and was not able to attend today. He asked the court to give a new control date, preferably the end of August, beginning of September, to give them an opportunity to test Mr. Purdue to see how he is progressing in his competency training.
No objection,
All
Your Honor.
right, what date did you want? I don't have a August or September
We
calendar.
have a miscellaneous date, looks like Thursday, September 7th,
Okay, hopefully he does good.
status hearing.
All right, thank you. Thank you, sir.
We've reached agreement in this matter, if I may approach, Your Honor.
Mr. Spears, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God? Thank you.
May I approach with a score sheet, Your Honor?
Yes. You want to enter an admission to violation of probation in 12 CF 1216 and 12 CF 1224? Is that correct, Ms. Rivers?
Yes, Your Honor.
You want to admit that you violated probation, Mr. Spears, in those cases?
He didn't hear you.
You do? Can y'all hear me back there? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
Sir.
Are you under the influence of any kind of medication or drugs that would prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work your attorney, Ms. Rivers, has done on your case for you?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge guilty on both cases. 61 days, Okaloosa County Jail with credit for time served since April 18th, 2023. Reinstate probation with all previous terms and conditions. $100 cost of prosecution on both cases. $100 PD fee on both cases. $50 PD app fee. Waive cost of supervision. You may do community service work for court costs, and you are adjudicated on both cases. Anything further?
No, Your Honor.
Thank you.
Mr. Taylor.
Your Honor, Mr. Taylor, this is William Taylor before the court on 20 CF 1695, 21 CF 1055. We would enter denial at this time.
Okay, thank you. What about, when's the next date for Mr. Taylor?
525 would be fine.
Okay, 525. Thank you, sir. Thank you.
You ready?
All right, Luke Truder.
I didn't sign it because I didn't have a pad.
Your Honor, if we could have just a moment for him to sign the document.
Okay. This thing,
Mhm.
I had a question about because, I didn't live here and that's what, I didn't understand that part.
Okay, so sounds like we're just going to have to continue it. So, Your Honor, I did meet with him yesterday and gave him the plea agreement to read and ask if he had any questions. He is now having some questions, so I'm just going to request to continue this to 525.
There's no objection, Your Honor, and the offer remains open.
Okay, thank you.
And I'll come back out. We'll
Okay.
talk some more.
All right, thank you. God bless.
Okay. I also, out of custody, had Mr. Robert Self. That would have been page 11, number 26 on my docket. And he wasn't here earlier, but he does appear to be approaching now, so.
All right, come on up, Mr. Self. We didn't enter a capias or anything?
No, Your Honor.
Okay. Robert Harold Self, okay, go ahead.
Your Honor, so we would enter a not guilty plea. We would leave this on the 626 docket.
No objection.
Okay, your attorney's pledged you not guilty, okay, so get with her, get ready for your June 26th, okay?
Yes, sir.
Thank you.
I did try calling you. Your voicemail was
I've got it
full or
messed up.
something was messed up about it.
Yes,
Yes, okay. Yes, I do, please.
I have actually Mr. Mason has appeared, Judge. I called him earlier.
Okay.
And then I've got one more that's out of custody, but I just filed a waiver of appearance for him. It's another one that's going to wind up being a plea, but it looks like I'm going to have to send him a
Is
written plea
this
in absentia.
Danny Burt Mason?
This is Danny Mason, Judge.
Did we issue a capias or anything for him?
You did.
We did, Your Honor.
All right, I'll withdraw or recall the capias. Okay, go ahead.
Judge, here's what I'm going to, I know that we're trying to get the case resolved, but I've got to get him in the office and meet with him. So what I can do is I can ask to set him on the second week, and then have him come in. I've already reserved all of next Tuesday, and I'll instruct him to be there at 9, and I'll use that to meet with him and then do any trial prep that needs to be done. Otherwise, I can move to continue the case again.
I would ask defense continue the case instead of setting it for trial at this point, this late in
About
the
May
game.
25th. I don't want you to
For
go to
call?
trial if you, huh?
For call on May 24th
25th?
or 25th, whatever.
Yeah, I mean, I don't want you to go to trial if you're not really quite ready yet for him. Is Mr. Mason working out of state or something, or is this the case where he was working in?
No, that's Mr. Harris that I called up earlier. I have heard from Mr. Harris, and I'll discuss him with the court in just a minute. Mr. Mason, I believe, is local, but does have a job, is employed in the afternoons, and that's why there's been a
Get with Mr.
miscommunication.
Williams and see if y'all can't get it resolved, okay?
Yes, sir.
I'll continue till May 25th court date, and if you can't get it resolved, we'll try the case, okay?
Yes, sir.
All right,
Thank
thank
you.
you.
Next Tuesday, the 9th, 9 o'clock in the morning.
Okay.
Thank you.
Yes, sir.
Then we got, okay.
Judge Alderon Harris is the individual I was just speaking of. Mr. Harris is going to be a plea. There were a couple of options given to him. He resides in Montgomery, Alabama, and does not have a driver's license. He tried to arrange a ride to get him here for today. There was a bit of a miscommunication. He was expecting me to do a written plea in absentia for him. If we can just continue him, I'll do up the written plea in absentia, send it over to him, along with the fingerprint card. He can get his prints done there in Montgomery.
All
and sent
right,
back
so
to
he'll
us.
be pleading to misdemeanors?
Yes, sir. It's
Okay.
a misdemeanor, improper exhibition.
All right, go ahead. We'll do that. We'll set him for May 25th.
May 25? Yes, sir. All right, everybody that I have left is incarcerated.
Is it Harmon or Harville? No, it's not Harville. Yeah, Kenneth Allen Harmon. Okay.
Judge, this is going to be a plea.
Mr. Harmon, would you please raise your right hand and be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir.
Thank you.
Mr. Harmon, I'll need to get your signature right there. Judge, I met with everybody yesterday, went over their rights. There were some where there was some renegotiation, and there's no pass-through for me to hand them anything back there.
I got you.
Put your Jane Hancock on that.
Yes, and this is the school sheet.
Here you go, Judge.
All right, in case number 22 CF 2121, Mr. Harmon, you want to enter a admission that you violated probation, correct? Did you read and sign this plea and sentencing agreement form, which tells you your rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
Sir, I'm not.
Are you happy with the work Mr. Williams done on your case for you? Court finds the admission freely and voluntarily entered. Court accepts it, reinstates, modifies to 6 months community control, balance on probation, 7 a.m. to 7 p.m. curfew, adjustable for work schedule, random UAs weekly, 6.
I'm so
I
sorry.
can-
The curfew should be 7 p.m. to 7 a.m.
Oh, it says 7 a.m. to 7 p.m., but, so it should be
Apologize, that's my error.
7 p.m. to 7 a.m.?
Yes, sir.
What is,
Yeah,
come tell me
we-
what this word is. This is hieroglyphics you got going there.
Judge, that's the kindest expression of that. Complete a new substance abuse evaluation and treatment. Get the evaluation within 30 days and the treatment within 60. That's why I normally type these
Okay,
up, Judge.
all right, okay. Complete a new, evaluation, treatment within 30 days, an evaluation.
Get the new evaluation within 30 days, begin treatment within 60.
Yeah, new evaluation within 30 days, treatment within 60.
Thank you, Judge.
All right.
And then, Judge, I guess
I think
there'll be
I missed my Egyptian hieroglyphics reading class that day at the University of Florida, so that's why I didn't get it, so.
Judge, I put myself through school working EMS in New Orleans. If I were in the back of a moving ambulance, that would be perfectly neat. It's
All right.
just adjusting for potholes that
I
are no
got you.
longer there.
Okay,
All righty, sir.
thank you.
Oh, over here, sir, I'm sorry.
All right. Good morning. Good morning. Donnie Henderson. Donnie Lamar Henderson. Okay, go ahead.
Mr. Henderson, let me get your,
It was, Your Honor, because it
Yes,
was
you-
previously adjudicated.
Yes, adjudicated. Y'all,
all right, if this is what you want to do, okay. 0.55, the cap on it would be 5. You don't want to do that. So I need to get your signature right here. You okay with you if I go ahead and date this? Yes, sir.
Mr. Henderson, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
Thank you.
I need to state, Your Honor, on the record, I was reworking and preparing again the score sheet in this case. I need additional time to submit them. That's all.
No objection, Judge. We had a preliminary score sheet that I reviewed with the client. This is just getting a clean copy for you to sign it.
If I may correct that belief. No, I need to review case law because I noticed in the prior criminal history, this defendant had several felony charges that, in my opinion, should be present in the score sheet, and currently they are not. So before I submit an amended one, I need to verify that.
Is it going to change the agreement, though?
As far as the state is concerned, no. We have agreed to a cap of 5 years DOC.
Well, actually, he's going to go ahead and accept the initial offer of the 20.55 months, which was
In that case, no, it's not going to change it. I just want to reserve the right to submit the proper score sheet later.
it would at that point be a legitimate uncoerced plea agreement and downward departure.
Should it be? Should it be? Yes.
Just put that on the score sheet.
Yes.
Is that okay, Ms.?
Yes, yes, Your Honor. Yeah,
Okay.
yeah. When we submit it, of course.
All right, so this is case number 22 CF 2150, 22 CF 2151. Donnie Lamar Henderson. You want to enter a, is it a no contest plea? Is that
Yes,
what
sir.
you're- On both cases?
Yes, sir.
All right, and that is in 22 CF 2150, a second-degree felony, written threat to injure or kill, and count 2, violation of a domestic violence injunction. That's a third-degree felony.
No, sir, the violation of DV injunctions first
Oh,
degree misdemeanor.
sorry, yeah, yes, first-degree misdemeanor. And in 22 CF 2121, written threat to kill or injure is a second-degree felony. So it looks like 2 second-degree felonies and 1 first-degree misdemeanor. You want to enter a no contest plea to those charges, correct, sir? Okay. Did you read and sign this plea and sentencing agreement form? All right. You aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here this morning?
No, sir.
Are you happy with the work Mr. Williams done on your case for you?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty on both cases, all counts. On the felonies, you're sentenced to 20.55 months Department of Corrections on each case concurrent, with court costs on each case, $100 cost of prosecution on each case, $50 PD app fee on each application, $100 PD fee each case, $310, $67 transportation costs. Was that to Okaloosa Sheriff?
That's correct, Judge.
On the misdemeanor, judge guilty, 7 months county jail with credit for time served concurrent with the felony cases. Adjudicated on all cases, all counts. Thank you.
And that's all cases, all counts concurrent, correct, Judge?
Yes, with credit for time served.
On all of them.
Yes.
Okay.
Mr. Langley.
How about it, Mr. Williams?
Okay.
Okay, I got no choice.
All right, you need to get your signature right there, man.
This is going to be a plea, Judge. You mind if I date it for you, sir?
Go ahead.
Okay.
Mr. Langley, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God? You swear to tell the truth, so help you God?
Yes, sir.
Can you hear me okay?
Yes, sir, I do.
Okay. This is case number 2023 CF 710, State versus Harvey Howell Langley III. Mr. Langley, did you read and sign this plea? Well, let me ask you this. You want to enter a no contest plea, the charge of possession of controlled substance, a third-degree felony, tampering with evidence, a third-degree felony, possession of prescription drugs without prescription, a second-degree misdemeanor, exposure of, count 4, exposure of sexual organs, looks like a first-degree misdemeanor, and possession of paraphernalia, a first-degree misdemeanor. You want to enter a no contest plea to all those charges, you understand that?
Yes,
Did you read and sign this plea and sentencing agreement form?
yes, sir, I did.
You aware of the rights you're waiving by entering this plea? You aware of your rights you're waiving by entering this plea?
Yes, sir,
Has anyone forced you or threatened you to enter this plea?
I understand. Yes.
Has anybody forced you to enter this plea or threatened
Oh.
you to get you to enter it?
No, they hadn't.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, I'm not. No, sir.
Are you happy with the work Mr. Williams, your attorney's done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Is he adjudicated on all cases, on all counts?
Yes, Your Honor.
Yes, sir.
Court adjudicates you on all counts. 12 months community control followed by 18 months drug offender probation. Controlled substance evaluation and treatment. No alcohol or controlled substance without a prescription. No associating with drug users except in group therapy or at NA or AA meetings. Mental health evaluation and treatment, including meds as prescribed. Do not return to Brown's Grocery in Holt, Florida. $100 cost of prosecution, $150 combined PD fees, $515 court costs, all misdemeanors. Counts are you're sentenced to time served in the county jail. Anything else?
No, Your Honor.
No, Your Honor.
Okay, thank you.
Your Honor, due to the fact that he has a public defender, we request the supervision fees be waived.
Okay.
Thank you.
Okay. All right. Mr. Lestrap, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
Thank you.
I still need to get his signature on.
Your Honor, I've previously provided a copy of the appropriate score sheet to Mr. Williams, and he'll provide it to the court if that's acceptable.
All right. This is 2022 CF 2016, State versus Kevin Wayne Lestrap.
That's correct, Judge. Just as be a plea to 3-year state prison with credit for time served.
Okay.
Sir, you object to my going ahead and putting the date in for you?
No, sir.
Okay.
All right. This is,
No, and it's a plea to 1 count. Judge State's going to drop the other count.
okay, this is,
My horrible handwriting.
that's all right. You want to enter Mr. Lestrap, you want to enter a no contest plea to the charge of failure to notify the sheriff of a established residence in the jurisdiction, is that correct?
Your Honor, if you like, I'll just put it on the record. It's a failure to notify the sheriff of the intent to establish a residence in another state or jurisdiction.
Okay,
And we would announce the null clause of count 2.
and that is failure to register, is that right?
That's correct, Your Honor.
So, okay, so they're dropping one charge against you, Mr. Lestrap. You're just pleading to one charge, okay?
Yes, sir.
And that's count one. And did you read and sign this plea and sentencing agreement form?
You're sir.
You're aware of the rights you're waiving by entering this no contest plea?
Yes, I do, sir.
Anyone force you or threaten you to enter this plea?
No, they did not,
Are you, okay. You under the influence of any drugs or medication that would prevent you from knowing what you're doing here today?
No, I am not, sir.
You happy with the work Mr. Williams has done on your case for you?
Yes, I am, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty, 3 years of, sentence to 3 years Department of Corrections with credit for all time served. We don't have a concurrent, do we? Because this is the only offense.
No, there isn't, Judge,
Is
I'm
that-
sorry.
That's correct, Your Honor, and then
But
court-
credit for all time served, court costs, standard, $100 cost of prosecution plus $150 PD fee.
Thank you, Judge.
How long has he been in jail on this?
Quite a while, Judge, many months.
Looks like August of last year, Your Honor. So it's not, the time's not all in yet.
Yeah, he probably served just a little bit, then be out, okay? Thank you.
Yes, sir. Thank you, sir.
All right, Christopher Warren Lucal.
Judge, can we pass him for just a few minutes? He's asked me to inquire the state if they would go with, well, I'll just ask him. You guys go with just straight time served on it?
90 days credit since the March 10th.
Right, he's asking if you'll just go with time served on it so that he can get out today, and then, you know, we'll pay fines, costs, whatever.
Pass it, and I'll look at it.
Okay. Go ahead, they're going to take you back, all right, and bring you back out in a few minutes.
Mr. Hanley, we're waiting on Luke.
All right, Benny Maurice Manley.
Judge, we're going to need to go ahead and pass him, put him on the next VOP docket.
Okay, what is that, 25th of May? All right, how about that date?
That's fine, Judge.
Okay. All right, thank you, sir.
Okay.
Morning.
Morning, sir. I'm Mark McCoskey.
All right, you're Mark McCoskey.
Yes, sir.
Would you raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God?
Yes, sir.
Thank you.
This one's allowed. Just, it came out weird, though.
Judge, this is going to be a plea. We've got a negotiated plea here.
All All right, this is case number 2022 CF 3101, 23 CF 854. All right, Mr. McCoskey, you want to enter in case number 22 CF 3101, a no contest plea to the charge of possession of controlled substance. No, excuse me. This is a violation of probation admission on the first three counts. Is that correct? Yeah, that's a VOP, right?
Yes, sir.
And then on count 5 is the introduction of contraband, a third-degree felony, correct? Is that what you're pleading? Is that, is that,
You've got two cases, Judge. One is a case from 2022 that is a VOP case.
Yeah.
And count 5 on that, I should have indicated that was a VOP as well.
okay, so that's not, well, see, count 4 is not, there's no count 4 indicated on this.
He finished count 4, Judge.
So count 5 is a VOP also, right?
That's correct, Judge.
Okay, because it was not indicated. So basically, 22 CF 3101, all of it's a violation of probation.
That's correct, Judge.
Okay, and then in 23 CF 854,
That's a new law violation.
okay, and that's a possession of controlled substance, a third-degree felony, and possession of paraphernalia, a first-degree misdemeanor. You want to enter a no contest plea to those charges?
Yes, sir.
Correct?
Now, Judge, he's not been arraigned on it yet. They just filed within the last couple of days. I'll go ahead and arraign him on that so that we can enter this plea.
Something new, or this, on this case?
On this 23 CF 854, Judge.
Okay, so you want to enter a no contest plea on the arraignment?
That's correct, Judge.
Okay, and that's what you want to do, Mr. McCoskey?
Yes, sir.
Okay. And you're entering a no, okay. And did you read and sign this plea and sentencing agreement form? Did you read and sign this form that
Yes.
waives your rights?
Yes, sir. Yes, yes.
Okay, you read it and signed it?
Yes, sir.
Okay. Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
And admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission of violation of probation and this no contest plea?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here this morning?
No, sir.
Has anyone forced you or threatened you to enter this admission or plea?
No, sir.
Are you happy with the work Mr. Williams has done on your case for you?
Absolutely.
Court finds the admission and plea of no contest is freely and voluntarily entered. Court accepts it. In 22 CF 3101, all felonies are concurrent. You're judged guilty on all felonies. Modify supervision of 1-year drug offender probation, followed by balance on probation, concurrent on each count. Curfew from 7 p.m. to 7 a.m. may be adjusted for work purposes. Attain a substance abuse evaluation within 30 days. Beginning recommended treatment within 60 days. Weekly UAs for 6 weeks. $100 cost of prosecution, $50 PD app fee, $100 PD fee. In 23 CF 854, judged guilty, 1-year drug offender probation, followed by 1-year probation. Curfew from 7 p.m. to 7 a.m. may be adjusted for work purposes. Obtain substance abuse evaluation within 30 days, beginning recommended treatment within 60 days. Weekly UAs for 6 weeks, $100 cost of prosecution, 50 PD app fee, $100 PD fee. Sentenced to concurrent with 22 CF 3101, misdemeanor, judge guilty, time served.
Your Honor, and just for clarification, count 5 of 23 CF 854 is adjudication credit time served, and counts 1 through 4 will be the probation concurrent.
All right. That's good. That's fine. Okay?
And Your Honor, request the supervision fees be waived.
Granted.
Thank you.
Thank you, Judge.
Thank you, sir. Thank you.
Okay.
Mr. Mobley?
Dusty Courtney Mobley. Okay. Okay. Mr. Mobley, would you please raise your right hand to be sworn? You swear the testimony you give before this court's truth, so help you God.
Sir.
Thank you.
Judge, we're not prepared to enter a plea today. We need to either, if we need to leave him on the trial docket, leave him on the trial docket. He did speak with me yesterday about the potential of hiring other counsel. Do you want me to continue the case to give you the opportunity to do that? And you'd ask for some documentation, and I have that for you. And also, I'll schedule, until your other attorney takes over, I'll schedule some time.
You want
with
to
my
try to hire an
investigator.
attorney, Mr. Mobley? Is that what you want to try to hire an attorney?
Yes, sir. That's what I'm looking into doing.
Has he had a lot of continuances or any continuances?
It's a fairly old case, Judge, I'll grant you. Again, I think this is one that I'm probably the second or third lawyer on. But he's apparently already been in negotiations with the other attorney's office.
What is, you have objection to one continuance?
I don't have an objection, Your Honor. There's 1, 2, 3, 4. There's 5 cases total.
I mean, it looks like he's,
They're on the 626 pretrial.
626, well, let's see.
I think the most recent case is about 8 or 9 months old.
Looks like he's got about 15 or so felonies, is that right?
Yes, sir. There's a lot.
Okay, well, we'll give him one more chance. 626.
Thank you, Judge.
Okay. Molly Nielsen.
Judge, she was given an offer with a couple of different alternatives. I did speak with her yesterday. She came up with a counteroffer that's been rejected. You need to get your signature right there. And then I confirmed with her this morning which of the two options she's asked for. And so I've scratched through. Do you mind if I date this for you?
Yeah, go ahead.
The option that she does not want.
Ms. Nielsen, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, ma'am. Yes, sir. I'm sorry.
And Judge, it's going to be a sentence to 4 months county jail with credit from the date of her arrest. We had discussions yesterday about the possibility of old time served, and that would essentially just mean adding that time to the 4 months that they were requesting.
Ms. Nielsen, did you want to enter a admission that you violated probation?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
All right. You're aware of the rights you're waiving by entering this admission?
Yes, sir.
You want to force you or threaten you to enter this admission?
No, sir.
You're under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
You happy with the work Mr. Williams done on your case for you?
Yes. May I speak, please?
Well, the question is, are
He's
you
done an
happy?
awesome job. I just have a question.
Okay, what is it?
Can I please get all my credit for time served on this?
Yeah, I mean,
The agreement is that she gets credit from her date of arrest on the VOP, which is for 1923. I believe that's in the plea agreement. And only credit since that date.
That's the agreement.
Can I plead directly out to you then?
No. I mean, you could, but I'm not going to change what your attorney and the state's agreed to, and you've agreed to by signing this agreement, then not go behind their back, but then suddenly you want to change something. I mean,
Well, Your Honor, I have been asking for the credit for time served, but I had just asked him when I came in here if I needed to plea out to you in order to be able to get on my credit for time served, and he, told me that that's what I needed to do. So honestly.
No, ma'am, no. No, I'm sorry. I'm allowed to defend myself if you state something untruthful,
Okay,
and I'm
then
allowed to clarify it. What you asked me was if you, what the chances were that you would get sentenced to just time served if you pled straight up to the court. And I explained to you that you could be sentenced to anything from 0 to 10 years, and that there was no way for me to predict what that was going to be. I explained to you last night that you've got a total exposure of 10 years, and that the state is willing to do 90 days less the credit from the date of arrest. If you wanted to, it'd be possible to figure out how to just kind of add up all your credit together and then add 120 days to that, and that would still be a legal sentence because it'd be well less than 10 years. So if you can, as far as I'm concerned, the plea hadn't been accepted by the court yet, you can withdraw it and then either go on to a contested hearing, plead straight up, do whatever you want to do. But now, in terms of asking for a particular sentence without accepting a plea agreement, yeah, the only way to do that is to plead straight up to the court and then tell the court, what you're asking for, and the court decide on that. And I'm good with that also. This is all completely
So that's something
your decision.
That's something I can do today then, is plead straight to the court?
If the court will allow it, yes, you can, but the court's just told you he's not likely to
I'm
do
not going to
anything.
change what I've just read, and you signed. I'm not going to open that Pandora's box. You signed this saying you agree. I asked you, did you read and sign this? And I asked you if anyone.
I apologize, Your Honor. I was misunderstood about all my credit for time served. That's the only thing I was confused about. Sorry.
Well, I'm getting ready to I'm not going to give you anything other than what you've agreed to under this. If I've already read it, you signed it, you said no one forced you or threatened you to enter this plea. This is what I'm going to give you, even if you plead straight up, because you've already signed it and I read it. You see, I'm not going to just, state agreed to let you, you were looking at 10 years in prison. And I'm about to give you 4 months county jail with credit for time served from April 19th, 2023. And I think you get a few days credit every month you serve. So, you're looking at probably, I don't know, you'll be out in, about 3 months or so? About 3 months.
Okay, Your Honor.
I'm not forcing you to enter this plea, and neither is Mr. Williams, or either is the state. Ms. Glisson is not forcing you to do anything, but I'm telling you, I'm not going to go back and change something the state's agreed to, you agreed to, you signed it. I'm not going to now go, I'll give you full credit, you're out. I'm just not going to do that. Okay? So you want to proceed by entering this admission that you violated probation?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea?
No, Your Honor.
You under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, Your Honor.
You happy with the work Mr. Williams done on your case for you?
Yes, Your Honor.
Court finds admission is freely and voluntarily entered. Court accepts it. Judge you guilty, 4 months Okaloosa County Jail with credit for time served since April 19, 2023. Revoke and terminate your probation, $100 cost of prosecution, $50 PD fee, PD app fee, $100 PD fee on each case concurrent. You're looking at 10 years. You're going to serve you're going to serve 4 months. sounds like that was a pretty good job on Mr. Williams' behalf. Okay? Okay. Thank you.
Your Honor, outstanding monies are 2 collections.
Yes.
Thank you.
Mr. Owen.
That is all I have.
Your
Unless you
Honor,
want
there
to
is
call
an
local.
unrepresented in the audience. He came up to me while Mr. Williams was,
I'll tell you what, why don't we have at least one public defender hang around till I can do the unrepresented people? Who we got that's unrepresented? Yes, sir, what's your name? Come on up.
Actually, Your Honor, are you here for an arraignment, sir? I represent Mr. Dowden on arraignment this afternoon.
Is it Dowden? Yes. Okay, good. All right.
I'm ready, Your Honor, Mr. Owens.
Okay, Mr. Owens.
Get Mr. Luke Hall to recall.
Is he on the morning docket?
Mr. Owens? Yes, sir.
Recalling Owen. 24.
Michael Paul Owen. Okay.
Yes, Your Honor.
All right.
We're here today on our motion to set bond. Your Honor, he's charged with a technical violation of his probation. He has a significant other who is very ill, requires constant medical care and attention. He's been given the opportunity to secure a new job that pays $25 an hour. And he is just asking the court for the opportunity to be able to do this. He's asking for an ROR or signature bond because he's unable to post any type of bond.
Well, what's the state say?
Judge, this is a VOP, so he's not entitled to a bond. He does score over 18 months in prison. The facts of this violation is somewhat disturbing. He's walking around in Gulf Breeze in Fort Pickens. People reported a suspicious person. He's asking strangers weird questions, and U.S. Park Rangers get involved, and he's got a 10-inch long blade machete in his backpack, and he told people that he had these items for protection of his fear of people involved with human trafficking. He also had a two-sided hammer, and the condition of probation was not to possess any weapons. He was on probation for pleading down to a lesser included of burg occupied dwelling. He pled down to an occupied structure, possession of a concealed weapon by a convicted felon. So this isn't the first time he's had a weapon. I'm not sure why this wasn't charged as possession of a weapon by a convicted felon, but the facts are disturbing, and the state would ask that his bond remain as it is. It's also his second VOP.
And Your Honor, in his first VOP, Judge Flowers did grant him bond. He did make all his appearances. That was a technical violation. This is a technical violation. He does maintain his position about the human trafficking, and he believes there's no room or concern or issue to be concerned about his behavior.
Well, go ahead, Mr. Rivers, I'm sorry.
He was just walking around and asking,
When probation confronted him about the issue, he said that he only had it in his bag because he worked for a tree company. So I'm concerned about his mental health, the safety of the community, that a convicted felon is walking around with a machete.
Does he work for a tree company?
I was doing side work for a company that was doing tree work at the time, and the hammer I'm sorry. First of all, is it okay if I address you myself, sir?
Well, I mean, anything you say could be used against you, but
And I
let me put you
understand
under
that,
oath. Would you raise your right hand to be sworn? Do you swear the testimony you give before this court's the truth, so help you God?
Yes, sir. So I was working for a company that was doing tree work at the time. I did not realize the machete was in the bag that day. The hammer, however, sir, is a hammer to do click-lock flooring. and it is a rubber hammer that's on both ends. The hammer was in the bag. I knew it was in the bag because I had a job to do click lock flooring that afternoon.
Well, how long has he been on probation?
Since 2019, Your Honor.
No violence, no new crimes, charges, or anything?
Your Honor, he just had the one technical violation.
What's,
in front
he's
of
got
Judge
some family member that's sick, or?
My significant other is going through medical problems at this time. Like, she's having to have a blood transfusion within the next couple weeks. They're saying that she's going to have like 3 or 4 surgeries within the next 6 months. She is disabled at the time. She has filed for disability. I'm the only breadwinner for us. Like, she's had to move in with her mother due to the fact that I'm in here right now. So, Your Honor, I'm just asking for an opportunity. I've never had an FTA.
So he is on a VOP, not a new charge, correct?
Yes, sir.
Correct, Your Honor.
Right.
It's a
His second
technical
violation of probation. And
Well, I'm going to go with a
It is a second technical, Your Honor.
$5,000 signature bond.
Thank you, Your Honor.
Thank you, Your Honor.
And don't mess up, and be aware, you may want to talk to your probation officer if you have any doubts about
I
your job
did-
requires you to have some rubber hammer or something with you, install those wooden floors that tap.
Well, that's the thing, Your Honor, is I did speak to them beforehand, and she said that it was fine for me to have
All
that.
right, well, we don't need to get into that.
Yeah.
5,000 signature bond, is that what I said?
Thank you, Your Honor.
Yes,
I
Your Honor.
appreciate
Yes,
it.
All
sir.
right, don't mess up. When's his next court date?
25th, I believe.
525, Your Honor.
May 25th, y'all see if you can work it out.
All right.
Thank you, Your
Thank you, Your
Honor.
Honor.
Thank you.
Your Honor, Tim Gibbs on behalf of Christopher Dowden. These are official charges. It's just your copy. Judge, this is 23 CF 800. He's on this afternoon's docket for arraignment, but he's here this morning. Judge, we'd like to enter a not guilty plea and set this for pretrial June 26th.
Okay. June 26th, okay.
Judge, I've been informed by the bailiff just now that he does have a warrant for failure to appear on a criminal traffic case that I believe is in front of Judge Ward. I don't know if the warrant says hold for first appearance or hold for, or no bond, or I believe it said 7,000 cash or professional bond.
I was under the impression that it was all today. I didn't.
Okay. Judge, since he is here, I don't know if you'd be willing to modify that. Otherwise, I believe that order was from Judge Ward.
Because I have no
Pardon?
reason to be running.
I gave you a copy.
So what you're doing is telling me that
It's on a criminal traffic case, Judge.
on a traffic case, a misdemeanor traffic case, you thought that was here in front of
Yes,
me?
sir. I'm not originally from here, and I just thought that it was all,
Where are you from?
I'm originally from Franklin County.
Oh, you came over here today from Franklin County? So
Actually, I've been here.
has there been a failure to a capias issued for him? Is that what you're saying? I'll recall the capias.
Thank you, Judge.
Thank you, sir.
And then you just stay on the same bond. I guess you posted probably, what, $700 to a
Had posted that.
bondsman? So when does he have to be in front of Judge Ward and me?
You have a date on that?
What's his court date in front of Judge Ward?
May I, Your Honor, just intervene for a second? I do not, he doesn't have a bond, he has an FTA in the city case, correct?
That's a CT case, yeah.
And I think Judge Ward has jurisdiction to modify that decision to revoke the bond for the FTA, Your Honor, not this court.
Well,
He issued a
I
warrant
thought-
for failure to appear. He needs to address the court, Judge Ward, on that.
yeah. When's the next court for Judge Ward?
I wouldn't know, Your Honor.
Is there a court date next week by chance? And I think our office may be appointed on that case as well.
Well, actually, Ms. Leone is correct. So you're going to have to be arrested, and perhaps I'll appoint the public defender, and perhaps they can talk to the state and get
I'll let
with
Mr.
Judge
Hall know.
Ward. Maybe they'll work out some stipulation today or whatever, but.
I can let Mr. Hall know with our office, and perhaps they can work out a release agreement.
Yeah, I see, you're under a different judge. I know. That's why I was willing to deal with it, but the state's objecting to
They
that.
released me, that's what they told me was today, that was when I needed to
So,
show up.
like I said, I'll let the misdemeanor attorney in our office know, and we'll see if he can try to.
Yeah,
get
the
a release
state
agreement.
is objecting to what I,
You know.
wait a second. Wait, hang on a second. His misdemeanor court paperwork tells him to be here today in front of me. Yeah, let's have a seat. I don't
Yeah,
want you to
let's-
go to jail, but
thank you.
we're trying to
Thank
work it out, okay?
Yeah, I appreciate that, thank you.
So, I mean, he's told one thing, he shows up.
And the clerk's indicating that he has a notice to be here today for the CT case.
Yeah, all right.
Yeah, that, we can see if we can get an order from Judge Ward today.
I don't mind putting people in jail. I do it all the time, but I don't want to if I don't have to, I mean, because it's an honest mistake. What else, who's next?
Mr. Lugo coming back from Williams.
Okay.
That's correct.
Christopher Warren Luco?
Oh.
Is that
Yeah,
right?
we recalled this so I could look at the case. I'm not going to comply with the request, so I would decline the counteroffer.
Essentially, we made a counteroffer or request for just straight time served. She's not agreeing with that. So you're,
Does it want to plead to my probation officer?
right, March 10th. All right, if this is what you want to do, okay? That's the March 10th.
Have we taken care of my arraignment, Doc? It seemed like we,
Things done.
I know, but it seemed like we've
Yes.
handled.
That's what we talked about.
No, the phase two period thing done, right?
Right. There's no action on a failure to appear.
Oh, in exchange for the plea?
Are we just about
Right,
finished
correct.
here this morning?
I'm not aware of a failure to appear, but go ahead. Right there.
6? I've got some I got some names that we still, let me, when we get through Mr. Luca, we'll go over them real quick.
You'll need a score sheet.
I got one, yeah.
Ms. Basso, do we just have McLean, Dixon, and Dumas for tentatively set for the May 18th trial
March
week?
10th, 23.
Is that right? Is that what, that's my notes from, is that Mr. Tony's cases? I mean,
None of those are actually my cases. Mr. O'Quain is my case with Ms. Rivers, and we did have that case set for that trial week.
which one?
It was Mr. O'Quain, the gentleman today that had requested the motion to dismiss that the court ruled on.
So what's his last name?
It's O'Quain, O apostrophe Q-U-A-I-N, first name Tyler, and that's with Ms. Rivers.
You want to set that for sure on?
Yes, please,
May 15th?
because I have a witness that's not available.
So that is going to go to jury trial on May 15th, correct?
Yes, please.
What about these other names I've got notes on?
I'm sorry, I don't know who those are, Judge, and not my cases.
McLean, Dixon, and Dumas.
Ladies? Dixon and Dumas?
I'm so sorry.
Judge is asking if they're going to trial.
Mr. Tony indicated to me that he may have plea agreements for both defendants today.
Dixon and Dumas, and he comes back at 1:30?
Yes, I believe our motions were set at 2 p.m. We had a motion to suppress
Right.
hearing. I think he's going to withdraw it.
What about McLean?
That I don't know. McLean?
I have McLean with Ms. Basso.
Your Honor, could that have been O'Quain?
O'Quain, okay, I must have thought you said
just thinking
McLean.
maybe that's what
Okay,
it
that's
was.
what happened.
So I have a Mr. McLean, but he's
O-
not.
So
he doesn't
O'Quain,
say McLean.
O'Quain. So it looks like we're having a trial on the May 15th. How long is that day going to be? you
Your
think?
Honor, it's with Ms. Rivers. I think exclusive of jury selection, I would say maybe a day. So say, let's set
Okay.
aside 2 days.
All right. Mr. Williams, sorry. Okay. Mr. Luco, you want to enter a admission to violation of probation, is that correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights? Are you aware of the rights you're waiving by entering this admission? Are you aware of the rights you're waiving?
Yes, sir.
Okay. Anyone force you or threaten you to enter this admission? Are you under the influence of any drugs or medication that would prevent you from knowing what you're doing here this morning?
No, sir.
Are you happy with the work Mr. Williams done on your case for you?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge guilty, sentence to 90 days county jail, credit for time served since May 10th?
March 10th.
March
Excuse
10th,
me,
Judge.
March 10th, 2023, revoke and terminate. $154.84 cost of transportation. Okaloosa County Sheriff's Department. Send all outstanding monetary obligations to collections adjudicated. Anything else?
Nothing.
All right, thank you.
Thank you, Judge.
Thank you.
All right, sir. Take care, okay?
You want paperwork?
Yeah, they'll have some paperwork.
Let me ask about some cases. What about Mr. Bryson Gurney?
Your Honor, Mr. Bryson Gurney is with Mr. Gil Powell as defense attorney and Ms. Barrickman as the state attorney representing that. I believe Mr. Powell indicated that he was canceling the hearing for today. He was in Walton County, and I believe they've resolved it.
Okay. Then what about Madison Beatty with Brandon Stewart?
That shows that it was
Canceled. Julius Sledge.
Judge, I don't see him present. He was here on, day were we here this week, Monday? Is that our other court date this week? He was here on Monday. He was supposed to hire another attorney. He knew to be here. He was told verbally. We were setting him for today. He had fired his last attorney.
Okay, no bond, capias. All right, come on back up. I think I have good news for you. Judge Ward has said that he's recalling that capias. And so this is Mr. State versus Christopher Andrew Dowden. So Now, when does he need to be in front of Judge Ward or me?
Judge, on this case, 23 CF 800, we'd like to put it on pretrial June 26th. I don't know when Judge Ward's next court date is. I believe we are appointed. Okay. May 16th, plea date, 9:30.
That'd be in front of Judge Ward,
In front of Judge Ward.
and then he's got a different day in front of me, correct?
June 26th, Judge.
Okay, so is he going to get some written piece of paper here? We'll print you out a paper and,
What you also need to do to make sure you get a... The front door, fill one of those out, give it to the clerk.
all right,
Let our attorney know.
make sure you're not late, okay? I saw you here timely, but, okay, now, what about, what do we got for, Vavebav Paul, or Powell, she'll, is that this afternoon or
Your
something?
Honor, I did speak to Madam Clerk. That's with Ms. Gooden, and I confirmed with Ms. Gooden that on Monday at pretrials, the motion hearing was moved to 5:25, and the case was continued. So we expect to address that on 5:25, and I'll have a written response to the court before that.
All right, Jeremy Dixon, that's one of the ones with Mr. Tony Dumas. Are these still on our docket, or are they removed? Is that for this afternoon?
Those I don't know, Your Honor, sorry.
This afternoon?
Yes, those will be at 2 p.m.
And then Baggett, Crothers, Craddock, these are this afternoon?
Those are at 1:30, yes.
All right, so at 1:30?
Yes.
Okay, so everything's done, right? Back there, are you just waiting for him? Okay. All right, anything further? Till 1:30, right? Okay. Sorry I went so slow today. I got taken up by some defense attorneys arguing motions and stuff. Miss Leone, she knows the law, and she makes sure I follow it, so, okay, thank you. We'll be in recess till 1:30.